Hello, everyone. Thank you for joining me tonight. I'm super excited to see everyone. How is everybody?
I'm fine.
Good, good,
Good
good.
evening, Christina. I'm fine. How are you?
Hi. Good, doing good. All right, so let's get started. Thank you for joining me tonight. So tonight we're going to be going over a webinar teaching you how to set up a trust, like what the steps are involved. And at the end of the webinar, I will be showing you what an actual trust document is. So I'm not sure if you're familiar about trust, if you ever, if you have a trust or if you ever even heard of the word trust before, okay, as an entity. So we are going to get started. Allow me to share my screen. One moment, guys. Technology.
So we can see.
All right, I'm gonna mute everybody and we're gonna get started. Let's see. Perfect. Oh. All right, so welcome to the Wealthy Trustee webinar. So like I said, tonight we're going to be, talking about how to set up a trust. So who is your instructor? I'm your instructor. My name is Christina Ivette. I am a passive income strategist. So I have helped hundreds of people set up passive income utilizing the strategies that I'm going to go over in this training, okay? I have been a trustee since 2015. So that is when I set up my first trust. And the reason why I set up my first trust is because I was becoming a real estate investor. So I started a real estate investment company and I was in the business of flipping houses. And if you ever flipped a house before, or if you're familiar with the process, like how they show you on the TV shows, it can be, a high liability business. Okay. So I didn't want to put myself in a position to get sued if one of these independent contractors or contractors got injured on the job, right? If they stepped on a nail and then they would sue me because they got injured at the property, then that would be very detrimental to me. So that's why I decided to set up a trust and I purchased that property under a trust. Okay. So like I said, I've been a trustee and operating with trust entities in my structure since 2015. Okay. And one thing that I like to do is just show you guys an example of what my structure is. Okay. So this is the Secretary of State's website. Okay, so you can see here the name of my real estate investment company. And then if you scroll down here, you see the authorized member. So the authorized member of this company is Urban Holdings, Inc. Okay, so now if we go do a search on Urban Holdings, Inc., then let's just go see who owns that company, right? So that's a corporation. And so if we scroll down here, we know that corporations have CEOs and presidents and stuff like that. So the chief executive officer of Urban Holdings, Inc. is Ways to Wealth. So what do you think Ways to Wealth is, guys?
Trust.
Exactly. All right. See, we got somebody in the house that knows about trust. So that is exactly what it is, right? It is a trust. Okay. So let's see, where is my presentation? There it is. So that's exactly what it is. It's a trust, guys. So the trust owns the holding company and the holding company owns the LLC and the LLC owns the properties. Okay. Or they're holding the properties while they're being rehabbed and sold. So that's what the structure is. So now let's dive into, the presentation. So A quick disclaimer, this is not legal advice or tax advice. So I am not a licensed attorney or a certified public accountant. Okay, so please keep that in mind. I am a trustee and I have been operating like this since 2015, and I'm just showing you guys how you can build wealth and protect your assets. So the objective of tonight's webinar obviously is for you to know what a trust is, for you to know tax strategies, for you to understand the contributors to the trust entity, for you to understand how to operate a trust, the wealth strategies that you can use, and how to protect your assets, okay? So how do these companies pay no taxes? You guys are familiar with Amazon, right? Billion-dollar organization. Berkshire Hathaway, billion-dollar organization. Trump organization, billion-dollar organization, right? So how is it that these entities do not pay taxes, or they pay very little taxes, right? You have heard these billionaires say, I pay less taxes than my secretary. So how is that humanly possible? And the way that's possible is by using trust within their structures. So all of these billion-dollar companies and the billionaires behind them, they use trust. They have trust incorporated in their, in their structure. Okay, so I'm going to show you guys how you can incorporate a trust inside of your structure as well. Okay. So you see the dollar bill here, right? So we see the United States Federal Reserve note. And my question to you is, do you see the word trust in this $1 bill? And you can come off of mute.
Yes.
All right, thank you, Sabrina. So yes, you see the word trust here. So you have to understand that the United States is a corporation and they operate under a trust, okay? So they have a trust, and it's called, obviously, the In God We Trust, okay? So they are operating their corporation with a trust as well. So if the United States has a trust, do you think that you should also have a trust? Another thing that I want to bring to your attention is that the United States, if you were, born here, if you have like, a birth certificate or a social security, they actually take out a trust. They create a trust for you automatically. It's called a 6-to-Q trust. And with that trust, they tie it to an insurance policy. So if they are using that type of instrument to have a trust under you, right? Because you have to understand that they have to provide, social services, and how are they able to do that is because they put out an insurance policy under you and they have you under a trust, but you are not the owner of that trust. The United States is, okay? So they are using trust. You should also be using trust as well, okay? So what is a trust? A lot of people, they've heard the word, they always use, I always hear this trust fund baby, right? So you guys need to be in position to where you're building generational wealth and you need to have your kids be trust fund babies, okay? So what is a trust? A trust is a entity, okay? It is a living, breathing entity. That is how it is identified, okay? It's identified as a living, breathing entity. It pays its own taxes, right? So you as an individual, you pay, or you file a 1040 and a trust files a 1041. So it is a separate entity from you, okay? A trust is a contract. So that's pretty much what the entire structure is. It's a contract between certain parties, which will go through those parties. So some names that we use interchangeably with trust is indenture. Indenture means agreement, and an agreement is a contract, okay? And then we use declaration. So you are declaring that you're creating a trust estate. And the reason for a trust is an entity that is created by an individual for the benefit of someone else. Okay. So for the benefit of a beneficiary. Okay. So we will get into the different parties involved in this contract, but pretty much the best use for a trust is to actually use it for asset protection and for transfer of wealth. Because a lot of us, we are in the business of creating generational wealth and we're making, hundreds of thousands of dollars, but we don't think how are we going to transfer this wealth, right? So we'll get into that in just a moment. So who are the parties involved, right? So we have the grantor. Another name for the grantor is settlor. Another name for settlor or grantor is trustor. So you can use all three of those names interchangeably in your trust contract, okay? And that individual is the creator of the trust. So the actual person who's putting the trust together, okay? And so the grantor creates the trust for the beneficiary, okay? So the next party involved is the trustee. So the trustee is the controller of the trust. Okay, so they're the individual who control all the assets and they manage and operate the trust on a day-to-day basis. Okay, so that's the position that you want to be in. You want to be in the position to where you are controlling the trust. You are the fiduciary, which is the person who's authorizing, for all of these assets to come into the trust, out of the trust. Okay, so that is your position. Just know that and be aware of that. Out of all three of these positions, the number one position for you as an individual who's building generational wealth is the trustee. Okay, the next party involved is the beneficiary. So who's the beneficiary? So that person is the inheritor. So they are the individuals who are the heir to this generational wealth, and they are the individuals who are going to receive the assets once the trust is dissolved. So one thing about a trust is that I told you earlier, it is seen as a living person, right? Or a living entity. So that means that it has a birth date, right? So it has a day that it was established. So let's just say that date of establishment is today, right? So today is the day that you created your trust. It also has a termination date. So the termination date is the day that the trust is going to die or expire or be dissolved, okay? And what you can do, which is really unique, is you can actually renew that. So you can renew your trust whenever it's due to expire. So you have to do it at least 30 to 60 days before it expires. You do not want your trust to expire, because at that point in time, like, it obviously experiences a death, and then those assets are going to go to the beneficiary. Okay, so just obviously keep that in mind. Now, the best practice for as far as term of how long you're going to operate your trust is, we want you to operate your trust for a minimum of 7 years. Okay, 7 years is a good time frame for you to really understand and operate as a trustee, and you can operate it for a maximum of 100 years. When you are creating a trust, you're creating an estate, you're creating a legacy, and you have to understand that this trust is going to outlive you. Right. And so if this trust is outliving you, and you automatically know that, then you don't want to renew it every 7 years or every 10 years. You want to set it for 100, and whoever's the trustee at that time is going to have that fiduciary responsibility to renew the trust. Okay, so just keep that in mind. All right, so the appointed duties, right? So like we said, we have the grantor, which is the creator. So they are going to appoint the first trustee, or what we call the founder trustee, right? So your contract or your trust is between the creator or the grantor and the first trustee, or the person who's going to be controlling it, okay? And another thing that the grantor is responsible for is transferring assets into the trust. And they can do that at their own discretion. So it depends on the type of trust you have. So if you have what we call a non-grantoring trust, that means that the grantor has no power in the trust. Or an irrevocable trust, they have no power and they have no influence over the trustee, so they pretty much walk away from the trust. Okay, so they create the trust for the beneficiaries and then they walk away. Okay, you have the trustees. So the trustees, they are the ones who are going to be investing the trust funds. So they are going to also be, paying the bills and the financial responsibilities. They're going to be managing the assets, and they are going to be responsible for appointing their successor. So you have to you have to understand that the trust, has to go on. So you are going to be the trustee, but the trust is going to outlive you. So you need to appoint someone to be your successor. And that person needs to obviously qualify. They need to understand and learn how to operate a trust, and they need to accept that position. Okay. So keep in mind that you have to actually create or appoint a successor so that the trust can continue to operate. Okay. And this is, if you decide to resign as a trustee, or if you become incapacitated, or when you expire, right? That's when the successor takes over. Okay. Okay, so the beneficiaries, right? So what are their duties? So the beneficiaries, they have no power whatsoever. They can't tell the trustee what to do. They can't, tell the grantor what to do. They cannot pretty much do anything when it comes to the trust, right? And so what the beneficiaries, what their duty is they need to have a clear understanding of the trust, right? So they need to read the trust, they need to understand the trust. They need to know what the trustee powers are, right? Because the trust is created for the beneficiaries, and they are the ones that are receiving distributions and the benefits of the trust, right? And eventually going to take over the assets or take over as the trustee. So they need to understand what the purpose of the trust is, what are the contents of the trust, and understand the trustee duties. Okay. We have another appointment, which is a protector. So the protector is an optional, it's an optional position that you can put in, and it's pretty much what it says. It's to protect the beneficiaries, right? Because what we've seen, in trust law is that there are beneficiaries that have sued the trustee because trustees mismanage funds, right? They get into the wrong investments, and guess what happens? The wealth dissipates. And then who's responsible for that? Well, unfortunately, the trustee that actually mismanaged the funds, they are not responsible because they don't have any liability with the trust. So that's why we have a protector, right? And so this is, like I said, optional, but they are watching over the trustee, making sure that the trustee is operating in their fiduciary responsibilities, right? Everything that the trust says that they can and cannot do, make the protectors making sure that that individual is doing that. They can do audits. They can, make the trustee resign if they see that the trustee is mismanaging and or dealing unlawfully. Okay, so you are not going to appoint a protector now because you are the trustee, and you don't need to appoint anyone that's watching over you. So you want to consider this in the future, right? When you step down, when you retire, when you're not operating your trust anymore, you want to put a protector in place, because the new trustee, they might not know how to manage the trust properly. Okay, and so this protector is like a third party person that is not related to any of you guys, and their sole purpose is to protect the beneficiaries. Okay. So we have several different types of trusts. You have to understand that there's hundreds of trusts out here. Hundreds. You have living trust, you have testamentary trust, you have land trust, you have charitable trust, you have irrevocable trust, you have revocable trust. There's so many different types of trust. I'm going to tell you the best type of trust to have, right? So, and we can, there's a lot of different classifications, right? So you have simple trust versus complex trust, right? And with a simple trust, the simple trust has to give distributions, right? They're forced to do so. With a complex trust, you don't, right? You don't have to. So it's up to the discretion of the trustee to decide if they want to give distributions to the beneficiaries or not. Okay. So a complex trust is one of the best types of trust to have if you're going to have those two, right? You have what we call implied or express trust, right? An implied trust is an oral trust. Don't nobody want an oral trust, right? You want something that is in black and white, it's written down on paper, and it's signed, okay? So please do not go out here creating an oral trust. You want an express trust, which means that it's written and it's in a contract form, okay? And let's talk about irrevocable versus revocable, right? And this, I hear this topic all the time, and a lot of people, they don't understand the strategy. So what is a revocable trust? A revocable trust is where the grantor is able to revoke any assets that they put into the trust. They are able to terminate the trust or dissolve the trust at any point in time, and they are able to change the trust, right? So they can make changes to the actual contract. That's what a revocable trust is. And that applies to the grantor, right? And with a revocable trust, because it can be changed and altered and things of that nature, it doesn't really hold up in court, right? It's not what we call a bulletproof trust. So what we call a bulletproof trust is actually a irrevocable trust. An irrevocable trust is where the grantor or the creator is not able to take back assets, right? So they can't revoke assets. So if the grantor wanted to take back assets, then the trust would have to sell it back to them, okay? They are not able, the grantor is not able to make any amendments or changes to the trust. And they are not able to dissolve the trust, right? They can't terminate the trust. So that is what an irrevocable trust is. Because it is irrevocable, it is more powerful, it's potent, right? And so trust falls under contract law. Contract law is the highest form of law in this country. Everything revolves around a contract, right? You live in a place right now. You live in an apartment or a house. You have a contract, right, to live there. You have utilities on. You have light and running water. You have a contract with the electricity company. You have a contract with the water utility company. So you have to understand that you are dealing with a contract every single day. So that's you dealing personally as a human, right? As an entity. But what you want to do is you want to switch it up, right? Now you want to deal contract to contract versus human to contract. And so the way you do that is by operating a trust, because now you have a contract and you become on the same level as these other entities that you are, getting into contract with, okay? So with that being said, you definitely want an irrevocable trust. You definitely want an express trust, and you definitely want a complex trust. Now, I'll tell you a different classification. So there is what we call statutory versus non-statutory trust, okay? And so the difference is that a statutory trust is a trust that is created by I would say by a lawyer, right? It could be any individual, but typically by a lawyer. So you have to understand that lawyers, they pass the bar, and so they have to abide by the legislative law, right? So they have to abide by the state statutes and codes of whatever state that they practice in, right? And they can't practice in other states, right? So a lawyer here in Florida can't go to New York and start, practicing, okay? Can't represent people. So with that being said, if you're going to a lawyer in your state, they're going to give you what we call a statutory trust, meaning that you can only use that trust in that state, and that trust, one, is registered because the lawyer is going to register it, right? Then it's available on the public records, right? And then that trust has to abide by and is going to be regulated by the state statutes and codes for whatever state you form that trust in. That's a statutory trust. You don't want that kind of trust, okay? So on the contrary, we have what we call a non-statutory trust. A non-statutory trust operates under common law. So that is prior to the Constitution. So that is operating under the Republic of the United States or the Republic of that state, okay? So with that type of trust, because it's non-statutory, it doesn't have to abide by the state statutes and codes of whatever state it was created or whatever state it resides in, because a trust is a living entity, so it has an address, okay? It has a residency. So whatever state that trust is a residency in is what we call the domicile, okay? So with that being said, let's just say that you are creating your trust in Florida, right? Your trust, because it's a non-statutory trust, it's operating under common law, then it doesn't have to abide by, or and it's not going to be regulated or restricted by the state statutes of, of Florida, right? The state statutes and codes. So with that, what that means is that you can actually operate a non-statutory trust in, in the entire country. You're not limited to Florida. So if you reside in Florida, but you want to, buy land in Minnesota, then you can do that. And you can operate your trust in Minnesota without any interference from the state of Minnesota or the state of Florida, because with this type of trust, you are governing yourself, right? Versus other entities, which I'll get into, right? Usually we are operating like our business or our life with LLCs and S corporations. And with those type of entities, you created them through the Secretary of State. So that means that the state actually created that LLC for you. You didn't create that LLC on your own. You went to their website, you looked up the name, made sure it was available, and then you went ahead and secured it, right? So you created or filled out what we call the Articles of Incorporation on the Secretary of State's website, okay? So that means that the Secretary of State created the LLC for you. That means that your LLC is being regulated by whatever state that you form that company in, okay? Also, it's available on the public records, right? Which means that if anybody were to, they want to find out who the owner of this company is, all they have to do is go to the Secretary of State's website. They have to plug in, do a search, obviously plug in the name of your business, and then your name as the owner pops up. That puts you in a vulnerable situation, right? So you don't want to be in that position where you're in the public records and you're being seen as the owner of that business, because you become low-hanging fruit, right? People are now able to know that you are the one running this business and they can sue you. So I'll give you further examples of how to change that situation, okay? So you want a non-statutory trust, okay? So I know it's a lot, right? You want an express trust, which is written. You want a complex trust so that you can decide about distributions, which is good for your tax benefits. And you want a non-statutory trust so you can use it all over the nation. And you want an irrevocable trust because it's going to hold up in court because it can't be changed by the creator, okay? So that's the best type of trust. That is what we call a bulletproof trust, and that's the type of trust that you want to create, okay? You don't want to create a trust that's going to end up in court like a living trust, right? A lot of people that are out here, either, promoting trust or even lawyers, they are giving away living trust, right? And so a living trust is where you're the grantor, you are the trustee, and more than likely you're the beneficiary. And so that type of trust can end up in probate, and that's definitely not what you want. So I will tell you a scenario about probate in just a moment, okay? So how do you create a trust? These are the steps. One, you want to determine what type of trust you want to create. So we just went through that, right? You want the bulletproof trust. You want the irrevocable trust. You want the trust that is in writing, that is non-statutory, meaning that your state is not going to be able to regulate it, is self-governing. That's the type of trust that you want, right? Number two, you're going to determine the trust name, okay? So what are you going to name your trust? At this point, you can name your trust whatever you want, okay? So the best practice is for you not to name the trust after yourself, okay? Please don't go out and do that. I've seen that before, because that's a dead giveaway. So you are out here creating a trust to protect your assets and your identity, but you're going to name the trust after yourself. No. So put your initials, you can put anything, you can name it whatever you want, okay? If you are operating a business trust, you can also use names like co, you can use names like company, you can use abbreviations like LLC, corp, you can use those things when you are naming your trust. Your trust does not have to have the word trust in it, okay? So also keep that in mind, because a lot of individuals, they believe that their trust name has to end in the word trust. It doesn't. It's not like an LLC where an LLC has to end in the abbreviations LLC, okay? So that's good. So so just name your trust, whatever it is that you want to name it, okay? And you're going to appoint the different parties. So if you want the irrevocable trust, you are going to be the trustee. You're going to appoint yourself as the trustee. So what you're going to have to do is you're going to have to appoint someone else to be your grantor. Who is that individual? That individual can be anybody. It could be your next of kin. So it could be a parent, it could be a sibling, it could be, you know, your lawyer, your best friend, it could be your neighbor, whoever you want. But that individual needs to be available to actually notarize the trust with you, okay? So keep that in mind, but this is vitally important because when it comes to having an irrevocable trust, it's not irrevocable to the trustee. That's why you want to secure that position as the trustee, because you can make changes. So if you put a property into an irrevocable trust, you can take it right back out because you're the trustee, right? If you wanted to terminate the trust at any point in time, you can do that as the trustee. If you wanted to, you know, remove beneficiaries, if you wanted to make any changes, anything like that, you can do that as the trustee. You don't have any limitations. So, you know, and it depends on the type of trust that you create, but the type of trust that that I operate with and that I set up my clients with is what we call a discretionary trust, where you have full discretion over anything and everything. That means you have no limitations, right? So if there's something that is not mentioned in the trust, but it's happening, you know, in your day-to-day operations, you have that full discretion to execute on that, right? Because your sole purpose is to defend the trust at all costs, okay? So that's important. So you want to appoint yourself as the trustee, you want to appoint a next of kin or a best friend or somebody as your grantor. Then you want to appoint your beneficiaries, right? So your beneficiaries are your children, right? If you don't have children, it's your next of kin, right? You have to think about it. So if you were to die today, and you have $1 million in the bank, who do you want to have that $1 million, right? That is the individual that's going to be your beneficiary, okay? And then you're going to appoint a successor. So that is the person who's going to take over after you, okay? In the event that, you know, that you expire or anything like that. So once you have determined all the parties involved, you've determined how long you want to operate the trust for, right? So if you want the trust to go for 100 years, that's great. You already created the name. Then you are actually in the action of creating the trust agreement, right? So you are, you know, typing everything up into the trust contract. Once the contract is done and you have, you know, filled in all the necessary information, you are going to notarize the trust, okay? And that notarize, or that notary, however you say it, guys, the fact that the trust is notarized is what legalizes the trust, okay? So that is what actually births the trust, because like we said, we're comparing it to a human, right? So that's what establishes the trust, and now that trust can be, you know, operated. So if you are notarizing the trust today, then today you can operate. You can go out, get your EIN, your bank account, all these things, okay? So once your trust is legal, then you can go ahead and open up your trust bank account, right? So there's a couple steps that you're going to have to do before you open up that trust bank account. So first, you are going to have a board meeting, okay? And in your board meeting, and you guys have to understand that board meetings are super important when it comes to these entities. And if you're out here, operating an LLC already or a corporation, you should be familiar with board meetings, because I see it all the time where they've been operating a business for 4 years and they've never done a meeting before. So with this type of entity, the meeting minutes are like the life of the trust, okay? Everything goes down in the meetings, okay? So with that being said, you're going to have a board meeting, and in that board meeting, you are going to be describing what bank you're going to go to open up a bank account. So if it's Chase Bank, great, right? Whatever bank you want. You're also going to describe what type of account. So you're going to open up a checking account, a savings account for the trust, and who is the authorized signer. So that is obviously you, right? You are the trustee. You're the person who's authorized to sign on behalf of the trust for any type of establishment of this type of accounts, okay? And once that is done, then you're going to take those meetings with you, right, to the bank. You also want to take your EIN. So some people, they decide to get EIN, some don't. So when it comes to like a business trust, I would definitely tell you apply for an EIN, right? Because it just makes it so much easier for you to, one, be able to build business credit with your business trust, and get bank accounts, as well as get into other contracts where vendors require you to fill out a W-9. Okay, so you're going to have your EIN, you're going to have your board meeting minutes, and you're going to go down to the bank and apply for a bank account. And then at that point in time, they're going to open up the account. But you have to understand that out here in society, a lot of people, they're not familiar with trust. They've never heard of it, especially some bankers. And so they're going to try you. So they're going to ask you for your trust documents, and you are going to kindly decline, because your trust is private. So under the privacy rights, you do not have to disclose who the beneficiaries are, who the trustee is, or even produce your trust, right? Your trust needs to stay at home and not, out here with you in the streets. So you are going to let them know that they're violating your privacy rights and that they need to open up that bank account, or you just go to another bank, okay? But some banks don't even ask you for the trust documents. So it just depends on what bank you go with. The best practice is for you to actually open up your trust bank account with a bank that you are not already have an established relationship with personally. So if you are already banking personally with Navy Federal, you're not going to go to Navy Federal. You're going to go to another bank, Truist, PNC, TD, anyone else, okay? Because what they try to do is, if you're banking with them personally, you already have a personal profile, and they're going to try to merge that personal profile with your trust profile, and you want to avoid that at all costs, okay? Because then that can bleed into commingling funds, which we're not in the business of doing that either. All right, so after you are done opening up your bank account, you're going to fund that bank account with however much you want. So let's just say you're funding it with $1,000, right? You have to understand and document that $1,000 that you are now funding your trust fund with, that is the initial value of your trust, right? Because your trust is, like we said, it's an entity, but it doesn't have any value until you give it value. So you have to do that exchange. So you are now depositing $1,000 into the trust bank account, right? At that point in time, though, that's your personal money, right? That $1,000 belongs to you. So the trust is actually going to write a promissory note promising to pay you back that $1,000. So it's going to be from the trust to you in your personal name, and it's going to say, promissory note to pay back $1,000, with let's just say plus 5% interest for a 12-month period, okay? So that's the best practice. Now, after you're done, setting up your bank account and you're operating your trust, you want to transfer your assets into the trust. And that needs to be done ASAP because, like I said, let's just say that you own a property, right? If you own a property and that property is in your personal name and you die tomorrow, how is that property going to be transferred to your child's name? So that's why you need to transfer your assets as soon as possible because it's risky. It's risky out here, and we're trying to avoid probate. We're trying to avoid these creditors that are, coming after our assets, okay? So once you are done transferring your assets, and it's very simple to transfer assets. For example, if you are transferring your home, right, you do not have to sell your property to the trust. The way that you transfer the asset is right now you have that house and you have a warranty deed for that house. That's how you purchased it, right? And so with that warranty deed being in your personal name, what you're going to do is you're going to create a quitclaim deed. And that quitclaim deed is just saying that there's not going to be any claims against the title of the property, okay? And so with that quitclaim deed, you are going to deed the property over as a gift, and you're going to deed it over from your personal name, right, as the grantor, to the trust as the grantee, get it notarized, and then you're going to turn it into your local clerk of courts or your recorder's office. So whatever your county operates with, okay? Every county is different. And at that point in time, once you record the new deed, then it's going to be reflected in the public records, which means that now your personal name is removed and the new owner of that house is the trust. So that's how you transfer the asset into the trust, okay? That's, the best practice. Now, you're going to be operating the trust, right? So operating the trust, there's a lot of things, to do with that. But that is, for example, if you transferred your house into the trust, now the trust owns the house. So what happens next? The trust is responsible for paying that mortgage, right? So that is you operating the trust. You are paying the mortgage for that property now. You are paying the utility bills for that property now, the taxes, the maintenance, all of those things, okay? So whatever the trust owns, the trust needs to be a payer of. Okay, so if the trust owns your insurance policy, the policy premiums need to be coming from the trust bank account, okay? I'm trying to talk as fast as possible, guys, because I don't want to keep you more than an hour. So asset protection, right? Asset protection is one of the major reasons why you guys are creating a trust. You are trying to protect your assets out here. People are trying to sue you. Do not wait to get sued to then get a trust, okay? Have your trust, have your assets inside of your trust before that even gets that far. It also allows you to operate privately, right? You want to be out here operating privately and not using your personal name and not using your personal social security number that's tied to you, okay? So the trust can actually assist you in doing that, okay? So what can a trust protect you from? It can protect you from bankruptcies, right? It can protect you from heavy taxations, from divorce, from probate, from lawsuits, from foreclosure, right? And the list goes on, right? Even like student loan debt, all kind of debt, right? So let me give you an example of divorce, right? For example, let's just say that you have been married for 10 years and you decided to pick up some properties along the way, right? And those properties that you picked up while you were married, they are under the trust, right? So the trust owns those properties. Let's just say you got 10 properties, right? So now out of nowhere, your spouse, had a change of heart. They don't love you anymore. They divorce you, right? So at that point in time, the divorce is obviously a lawsuit between a husband and a wife. And with that being said, if you have like, a primary residence with your spouse and stuff, all of those things that are in your personal name are going to be included in the divorce, right? So whatever you have in your personal name, assets, debts, anything like that is going to be included in the divorce. But those properties that are owned by the trust cannot be included in your divorce. So you got 10 properties just sitting over there and they're not included in your divorce because your trust is an entity, and that entity has nothing to do with husband and wife. So those properties or assets that's in that trust is not going to be included in your divorce. Okay, so that's extremely powerful. Okay. Heavy taxation, right? So when it comes to trust can actually protect you from heavy taxation, because you have to understand that the government is going to get theirs and they're going to tax you any kind of way that they possibly can. So if you're using a trust, you can actually reduce your tax liability down to zero, right? Which is extremely important. So and it depends on the type of trust that you are operating too, right? Which is why I always tell people, like, you need a for-profit trust and a nonprofit trust because they work beautifully together, right? So with heavy taxation, you have what we call an estate tax, a death tax, an inheritance tax. You have federal taxes, sales tax, property taxes, all this stuff. So if you are using the nonprofit trust, right, the tax exempt nonprofit ministry trust, that trust is actually not subject to federal taxes. So you don't have to file any type of federal taxes ever again in your life when it comes to that type of trust. Okay. It's not required. You don't have to file sales taxes, right? You can be sales exempt, sales tax exempt. You just have to apply for that status. But when it comes to the federal level, you don't have to apply to be qualified to be tax exempt on a federal level. It's just automatic because that type of trust, which is called a 508c1a, is one of the exceptions to you having to apply for a 501c3. Okay, so that is extremely powerful because when it comes to, a 501c3, you have to apply, and there's a lot of rules, regulations, restrictions, right? They restrict your freedom of speech. You have to get all of your documents, your financials, you have to submit all of those things, and then you can also lose the status as well. So you have to apply, you have to get approved, and then you might lose it. So with that being said, the ministry trust, it can actually save you from even property taxes, right? So whatever, if that type of trust is owned by, if it owns the property, then you can actually be property tax exempt, okay? So that is one of the reasons why saving on heavy taxation is super, super, super valuable. What about probate, right? Probate is the number one thing that you want to avoid. So what is probate? Probate is where you have to go to court in order to pretty much get your inheritance. So, for example, if, like I said, if you guys have property in your personal name and you want to leave it to your child, right? The only way, and let's just say that you have a will, right? You have a will. A will is not going to prevent you from going through probate. A lot of people are misinformed, and so they go ahead and get a will thinking that, that their heirs is going to get the inheritance. But in fact, no, it's going to go through probate, and it's going to be up to the judge what happens with that, right? So with the will, it's not going to protect you. But if you have a trust doesn't end up in probate. So a trust is the only type of entity that can actually have you avoid probate. So the probate process, the way it works is you have a property and you want that property to be transferred over to your child's name. The only way for that property to be transferred to your heir's name is by going through a judge, right? There's no way for that property to be deeded over other than a judge doing it, okay? So if you die and your affairs are not in order, the state is going to issue you an estate, right? And when they issue you an estate, you then have to go through the probate process. So you have to go through probate court. Your estate has to hire a lawyer to represent, and then everything that you had, in your personal name is going to be included in the estate. So if you had a car, if you had a house, if you had a bank account with $1 million in it, all of that stuff is in the estate. But there's things involved, right? So one, they're going to charge your estate as taxes, right? I don't know if you guys know this, but they tax you when you die. So the IRS, you're an asset to them, and when you die, they need to tax you. So you're going to get a death tax, an inheritance tax, and an estate tax, okay? So those are monies that's going to be coming out of your estate. Then the court fees, right, for the judge. You have lawyer fees, and then also the debtors, right? So whoever you owe money to. So let's just say that you had student loans for $50,000, then those student loans is going to actually be taken out of your estate, right? So your estate started with $1 million, but now after all of these fees, it went down significantly, probably $700,000. So whatever's left over after the debt is paid and all the court fees and all the taxes is what your children are left with. So in order to avoid this whole process, what the best practice is for you to transfer your wealth through a trust, okay? And we'll talk about that in just a minute. So let's talk about lawsuits, right? When it comes to lawsuits, your trust can prevent you from getting sued, right? It can prevent you because one thing with a trust is that, like I told you guys earlier in the call, lawyers, they are operating under legislative law, right? So they can only practice here in whatever state that they're in. So if they see that, let's just say your business or your property is owned by a trust and an individual wants to sue your trust, sometimes these lawyers cannot even, they don't even have the capacity to initiate a lawsuit against your trust because they are operating under, under statutory law. And the court systems are also statutory courts, okay? Which means that your case is going to have to go outside of that jurisdiction. So it's going to have to go to the Supreme Court. Okay, guys. So that is that's an advantage that you want to take advantage of, because when certain lawyers or judges, when they see that there's a trust involved, they'll just dismiss it, right? They'll settle outside of court or they'll dismiss it because they know that they can't carry it through, okay? Which is powerful, but I'm not saying that trust cannot be sued, because it could definitely be sued, okay? So this is the wealth building formula. Let's definitely go through this so that you guys could find out some strategies that you could use in order to build wealth, okay? So let's start with structure, right? So how do you want to be structured? You have a business trust, you have a private family trust, you have a tax exempt trust. So first and foremost, right? Let's just say that you have an LLC. That LLC is owned by you personally. So you need to remove yourself as the owner of that LLC, because like we were just talking about with lawsuits, right? If somebody decides to sue your business, then they're going to sue your LLC. But if the judge decides to pierce the corporate veil, guess what happens? Because a lot of people, they don't understand that LLC stands for limited liability company, which means that your liability is limited. Okay, so if they try to sue the business and the judge pierces the corporate veil, then at that point in time, they can come after you personally as the owner of that business, right? And you don't want that to happen, because if that happens, then they can seize, your assets, right? They can garnish your wages, they can seize your assets, freeze your bank accounts. You don't want it to get to that extent, okay? So the best practice is for you to remove yourself as the owner of that LLC, okay? Because like I said, it's in the public records. They just have to pull up your business and they see that you're the owner. So now that you removed yourself as the owner of that LLC, you are going to add the new owner as your business trust, okay? So now your business trust is going to own your LLC. So all the money that is being generated from your LLC is going to flow obviously to the owner. So that means it's going to flow to your business trust, okay? Which is super valuable. So now in the event that your company or your LLC is being sued, it's now going to, and the judge decides to pierce the corporate veil, they're going to see that the owner is a trust, okay? And so then you are protected. That's your first layer of protection, okay? So that's super valuable. And so now, as far as a tax perspective, those funds that was generated from your LLC is now inside of your business trust, okay? And as long as those funds stay in your business trust, it doesn't trigger a taxable event. And when you are operating with a complex trust, you as a trustee decide if that money is considered income. Okay, and then if you decide that it's considered income, you could be taxed on it, okay? Because I'm not saying that this type of structure is not taxable, it is, right? A business trust has to file a 1041, okay? But you as the trustee determine if that income is considered taxable income, okay? So with that being said, all the money can either, it can either sit in your business trust, right? And then you do your expenses from there, or you can actually distribute it to the beneficiary. So the beneficiary of the business trust is going to be the private family trust, right? Because at the end of the day, you're out here conducting business. That's your bread and butter. That's where the money comes. So it needs to flow to the family, okay? So once it's at the family level, then you're going to use it to, expend on the family. That's where you're going to be, doing your vacations, you're going to pay your mortgage, your tuition, all of those things, okay? And then at that point in time, when you're taxed, so let's just say that you're flowing $100,000, right? So your flow, the LLC generated $100,000, it flowed into the business trust, and then from the business trust, you distributed it to the private family trust, right? So that $100,000 is just sitting in the family trust, you expended. You can expend it down to zero, right? Because one thing with these structures is that you get paid first, and then you pay taxes on whatever's left over. If there's nothing left over, then you pay taxes on zero, right? But if there is something left over, then what you can do is you can donate it, right? So that's why I'm telling you that it's super valuable for you to have a nonprofit within your structure, because you can donate whatever's left over. Let's just say out of that 100,000, there's 10,000 left over that you had to pay taxes on, right? You can donate that 10,000 to your nonprofit, to your ministry trust, to your tax exempt trust. And that trust is going to give your private family trust a receipt, right? So now when the funds get to the tax exempt trust, there's no more taxes that are due, because it's tax exempt, right? So you don't have to pay taxes on the 10,000 that you donated from your private family trust to your ministry trust, okay? And then at that point in time, with that 10,000, you can use it for, for whatever you want, right? As far as, and I don't mean whatever you want, because it is a nonprofit, so you obviously want to use it for charitable things, for philanthropic things. But also you can use it for investments, okay? So nonprofits can actually get into investments, and you can do, stocks, you can do real estate, crypto, whatever you want, okay? So that is an extreme benefit for you, okay? And let's just say that 10,000, you didn't want to do any investments or purchase any assets. The way that you can pull the 10,000 out of the nonprofit without triggering a taxable event is by rendering a service, right? So you're going to have your either your business trust or your private family trust, you're going to have them render a service to your nonprofit ministry trust, right? And then that trust is going to 1099 the other entity for that $10,000. So once it gets to that entity, if you want to use it personally, all you have to do is take out a loan, right? Because as a trustee and even as a beneficiary, you can take out loans from the trust, right? So if you needed to use that 10,000, all you have to do is just loan the 10,000 to yourself, do a promissory note. That does not trigger a taxable event. So you're not going to be taxed on that 10,000. So these are strategies that you have to understand in order for you to build wealth faster by not giving half away to the IRS and for you to build wealth effectively. Okay. So the number one question that a lot of people or a lot of my clients ask me is, how is the trust going to generate its own income, right? Because we are in this phase where we're building generational wealth, right? And so you want the trust to be self-sustaining. You want the trust to have its own income. So the way you do that is by using credit, right? You can fund it yourself if you want to, but one way that you can do it is by actually using credit. Okay. So with your business trust, you can actually build business credit with it. Okay. Hold on, guys. One second. Thank you for bearing with me. So you can build business credit with your trust. So it's the same thing as building business credit with your LLC. Okay, it's the same way. So you guys are going to be, applying for credit. You can be a personal guarantor for that business, or you can do it independently by setting up a DUNS account, getting a DUNS number and applying for net 30s and establishing that corporate credit for your trust, right? Because that initial credit that you are generating with your business trust can be the down payment for real estate, right? It could be the funds that you need in order to operate, right? Also, because you're running a nonprofit with your ministry trust, you can actually qualify for nonprofit grants, right? There's a lot of grants out here with nonprofits, even systems that you can get, 50% off, or they just give it to you for free. So there's a lot of benefits, especially as an entrepreneur, for you to be utilizing a nonprofit in your structure. Okay. So now that we have the nonprofit grants, now that we have the corporate credit, right? Let's just say that we have a line of credit of $50,000, for example, right? What are we going to do with the money? We are going to invest. Okay. So there are two investments that I love to share with you guys, and there's multiple, right? You guys could do crypto, you can do whatever you want, right? But now in these times where, the economy is uncertain, I recommend that you invest in obviously tangible assets, right? Precious metal, real estate, and liquid assets, which is your insurance policy. Okay. So you want to be doing like what they call infinite banking. Have you heard of like infinite banking, private family banking, be your own bank? They have so many different names for it, but the concept is the same. Okay. So with this strategy, you are going to use your insurance policy as an investment. Okay. And so what you're going to do is you're going to pay yourself first. That is super valuable. You can do this with a whole life policy. You can do this with an index universal life insurance policy. So me personally, I have an IUL policy for me and my entire family. Okay. And so the way that this works is whatever you generate, right? Whatever income you have, like on a, on a monthly basis, you are going to flow that income into your insurance policy, okay? Because with an index universal life insurance policy, it's tied, or not tied, but it mirrors the market, okay? So it's not inside of the market, but it mirrors the market. So usually, like, you're going to choose an index, right? You're going to choose the NASDAQ, the Dow Jones, the S&P 500, right? So I've chosen the S&P 500, and with that index, generally it does, anywhere between 7 to 10% on an annual basis, which means that whatever money that you're putting inside of your policy is going to generate 7 to 10% on an annual basis. Okay. So the concept of you paying yourself first is this, right? So typically what happens, we get paid, right, on our W-2 or whatever, or even in our business. And what is the first thing that we do? We pay our bills, right? So we pay our mortgage, we pay our groceries, tuition, car note, gasoline, and the list goes on. So we are actually paying all of our bills first, and whatever's left over is what we save. Well, that's not what we're going to do anymore. We're not living like that anymore. So what we're going to do now is we're going to pay ourselves first, and then pay all of those, liabilities second. Okay. So this is how it works. Let's just say you got paid today and you got $10,000, right? So that $10,000, right, the whole entire thing, instead of you paying your mortgage and groceries, you are going to put it inside of your insurance policy first. You're going to pay yourself first. Okay. So you're going to obviously pay the premium, put the 10,000 in there. It's going to go into your cash value. Okay. So now your cash value grew by $10,000. Okay. And that money, obviously, in your cash value bucket is going to be growing, like we said, at 7 to 10%. Okay. Which is super valuable, because now you are generating compound interest with this type of investment. So next, that money is already parked in there, making 7 to 10%. What are you going to do? You need to pay your mortgage, right? So you are going to take out a loan against your policy. Okay. So you're going to call the insurance company and let them know that you want to take out a loan. And that loan, that money, the $10,000, is going to come from the insurance company's money, from their reserves. Okay. It's never taken out of your policy. So that 10,000 is working inside of your policy, generating compound interest, and the insurance company is now going to issue you a disbursement. It's going to be direct deposit, and they're going to put it inside of your bank account for the 10,000, because your life insurance policy is an asset. Okay. A lot of people, they don't understand that. Even like all these banks, Bank of America, Wells Fargo, their number one assets is insurance policies. Okay. Because it's liquid, and it's tax-free. Okay, so you need to be using these type of tools in order to be building wealth faster. Okay, so with that being said, you are going to borrow the money back out from the insurance company's money. And now that 10,000 is back in your bank account. So what are you going to do with it, right? You're going to pay your mortgage and your groceries and put gasoline in your car. Okay, so that is super valuable. Now, what you need to understand is that since you took out a loan for the $10,000 from the insurance company, they're going to charge you interest, right? So they're going to charge you, let's just say 2%. So if you make 10% on the 10,000 minus the 2% from the loan, you're going to net 8%. Okay. Another thing is that you never have to pay that loan back. So don't think that you have to pay them $10,000 back, because you don't. It's deducted from your death benefit, okay, which is super valuable. So that is the concept of you doing infinite banking and you paying yourself first. Now, the strategy behind this is that the trust needs to be the owner and the beneficiary of that policy, okay? So you as the living human, you are the insured, but the trust took out the policy for you. Or if you already have this type of policy, then all you have to do is contact your insurance company and tell them that you want to change the ownership and the beneficiary from your personal name or your kid's name to the trust, okay? So now at this point in time, your private family trust owns the insurance policy on you and all of your children, all of your beneficiaries, okay? So, so the trust is actually going to be responsible for paying the premium, okay? Another thing is real estate, right? Real estate is, it's great. So real estate is awesome. You know, you're getting that passive income, and that is one of the, best types of investments to have, okay? With real estate, one of the benefits with utilizing a trust, and I'm just going to talk briefly about the ministry trust, is let's just say that you have the ministry trust, right? And the ministry trust owns the asset, the house. You now have a tenant inside that house. That tenant is paying you $2,000 per month, right? So that tenant is actually considered a member of your ministry or your faith-based organization, okay? So that $2,000 is actually a donation. It's a donation into your ministry trust for $2,000 every single month from the member. So you do not obviously have to pay taxes on donations, right? And then with that being said, that's one of the benefits. The other benefit is that because the property is owned by the ministry trust, you do not have to pay property taxes. Property taxes are extremely expensive. I'm not sure what your taxes are, but my taxes are over $7,000, okay? And so if you have this type of, if you have a property, and it could be any kind of property, it could be land, it could be anything, right? But with the ministry trust, it only qualifies for one property, right? Because it falls under, the concept with the ministry trust is that it's the separation between church and state, right? So another name for a ministry trust or, a 508c1a designated trust is a church, okay? And a church only has one structure. So with this type of trust, you only qualify for property tax exemption for one parcel, one structure, one piece of land or a house, okay? So like I said, you're going to be saving $7,000, $8,000 per year on an annual basis by having that real estate property be owned by the ministry trust. That's one. And then two, that rental income is considered a donation by your member. Okay. So now when that money is in the trust, in the ministry trust, what are the ways you can take it out, right? You could render a service, 1099 yourself. As long as it stays in the trust and you issue yourself a loan, then you can use the funds personally for whatever you want. It's just paperwork, guys. Once you learn this information, it's going to be like clockwork for you, okay? But you have to know how to actually become a trustee and operate your trust efficiently, effectively, legally, lawfully, okay? Because all of the things that I'm describing to you right now are legal. Nothing that I'm telling you is illegal, okay? So you want to be building a whole real estate empire out here, especially utilizing a trust, okay, guys? Let's see. I think we're about to wrap it up. Oh, no, not yet. All right, we got, I'm going to try to finish this in about 5 minutes. So how to transfer your wealth, right? You are going to be putting yourself in the position to where you own nothing but control everything. Own nothing but control everything. That's one of the most powerful statements ever, because unfortunately, all of us, we are building generational wealth, but we do not think about how we are going to transfer this wealth. So we out here making hundreds of thousands of dollars, but we never think, how is this property going to be transferred to my child, right? Or how is this $1 million that's in a bank account with my personal name going to be given to my kids, right? So with that being said, you have to think about the transfer of wealth, okay? So that's where stewardship comes into play. So you have to be a good steward of your wealth, which means that you are controlling everything. If you're off of mute, can you please mute? So that means that you are going to be controlling everything and making sure that your wealth is being handled the right way. Okay. So when it comes to a trust, right? A trust, it doesn't have an owner. Okay. So what we do is, in order to reflect your ownership, we use what they call trust certificate units. Okay. Trust certificate units, or the other name for it is UBI. UBI is units of beneficial interest. Okay. So it's identical to a stock certificate. Okay. So you know how you have a corporation, and if you buy stocks in that corporation, you now have ownership in that corporation. It's the same thing with a trust, right? So you have trust certificate units that are representing your beneficial interests. We don't use the word owners because a trust does not, a trust is a living entity, and a living entity doesn't have an owner. So like me, I'm a living entity. Nobody out here in these streets could say that they own me, right? And the same thing applies to you guys. So the same thing applies to the trust, okay? So nobody owns the trust. You just have beneficial interest in the trust, okay? And so the way that that happens is through the TCUs. So your trust is going to generate the trust certificate units, and those units are then going to be dispersed to your beneficiaries, okay? Once they're at your beneficiaries, that's what it represents. So your trust is going to generate 100 trust certificate units. Let's just say that you have, 2 children. Those 2 children, if you wanted to split it equally, each of those beneficiaries will have 50 units each, okay? And that's going to represent their, quote unquote ownership, right? Their beneficial interest. So then at that point in time, it'll also represent, like the assets, right? So if you had, let's just say you have 50 houses inside of this trust, right? And the trust is dissolved. Once the trust is dissolved, the assets go to the beneficiaries. So then, because they have 50 trust certificate units, it would be dispersed as each beneficiary would get 25 houses. So that's how it is reflected when it comes to, transferring wealth. But back to that, right? So right now, if you have a property in your personal name, how is that property going to be transferred, right? If you die today, how is the property going to be removed from your name or transferred from your name to your child's name? We don't think about that. So you're going to have to go through probate. You're going to have to go through court. The judge is the only person who can do it at this point in time, because you're not living anymore. Okay. And that is doing a disservice to your family, because when you pass away, they are grieving. But now, because you didn't have your affairs in orders, you're forcing them to have to go through probate, have to get a lawyer, have to battle in court while they're grieving over your loss. So please have your affairs in orders. So now, if you are, so to prevent this whole transfer of wealth, right, to streamline it, you are actually creating an entire distribution system. So what you're doing now is when you have that property under the trust and you die today, there is no transfer that needs to be made, because your child is the beneficiary and that property is going to stay under the name of the trust. And they are, they're the beneficiary, so they're going to benefit from that trust. Okay. And if you want them to take over as the trustee and control the assets, then that can also happen. Okay. So that's super valuable to understand, because a lot of people, we're so focused on making the money, but we don't think about, how are we going to make this money last for generations? And that's where preservation comes in, right? You have to preserve your wealth. And the way that you preserve your wealth is through the insurance policy, right? Because one, you're going to be benefiting from the insurance policy, obviously by it being tied to the market and you generating compound interest. That's one, right? But the second thing is that it has a death benefit tied to it. And anyone that's involved in the trust, including you as the trustee, you are a human resource. You are a human asset, right? The trust has many assets. They have tangible assets, right? And then they have human assets, which is you, the trustee and the beneficiaries. So in the event that you or one of the beneficiaries pass away, that you had a policy under the beneficiaries and yourself, right? Which means that the trust needs to be compensated because the trust just lost a human asset. So that death benefit is going to go straight to the trust fund. That is super valuable. Okay, that's how you're going to preserve your wealth, by doing things like that. Okay, that's safeguarding your wealth for generations to come. So every single time that there is a beneficiary that's introduced into the trust is going to take out an insurance policy on them as early as 15 days old. Okay, and it's just going to be a revolving cycle, right? You're going to continue to do this for generations and generations. Okay. So these are the book recommendations that I have for you guys if you guys want to learn about trust, right? What would the Rockefellers do? The Rockefeller family, they implement what I am telling you guys now, okay? The Art of Passing the Buck, Volume 1 and 2, Family Wealth, and the Complete Book of Trust. You can get all of these from Amazon, okay? So you guys want to take action. I gave you guys a wealth of knowledge tonight, okay? So you guys learned how to set up a trust, how to protect your assets, and why you want to operate privately, okay? So this trust, right, and this structure and this entire distribution system and administration system that you're creating is your new form of doing business, okay, and making profit. So it can solve a lot of the problems that you are facing today, as far as giving half of your income away and protecting the assets so that people are not, out here coming after what you're building, which is that generational wealth, right? So protect yourself. So you want to treat your business structure, right, your trust structure, as a big business, as a Google, as a Facebook, as an IBM, as an Amazon. That's the way you want to treat this. You don't want to treat this like something little, some mom and pop, some insignificant thing. No, you can build wealth fast, effectively, by using this structure, okay? By using this type of entity in your existing structure, okay? So if you want to work together, we can definitely do that. I have a course, and the course is it's a do-it-yourself. So it has a total of 40 modules. And in that course or online portal, you are going to learn how to set up the 3 trusts that we talked about, okay? So you're going to learn how to set up a business trust, a private family trust, and a 508c1a ministry trust, okay? And you're also going to learn how to operate it, right? Which is super important because, to be honest with you, I talk to hundreds of people, right, on a weekly basis, and people, they have trust already. And they bought a trust, they got it from a lawyer, they got it from an accountant or whoever, and they don't know how to operate it. Someone just handed them a stack of 20 papers and said, there's your trust. And they didn't know the first thing or the last thing to do. So the most important part about this whole thing is learning how to operate as a trustee and learning how to operate a trust. And so in the course, we teach you that, right? We teach you how to transfer your assets. We teach you how to do your board meetings. We teach you how to set up the trust. We go through every single paragraph inside of the trust so that you understand the contents of the trust, right? How are you going to operate a trust and you don't even know what it says? Think about that. So we teach you all of that stuff, right? So that you can operate effectively. And like I said, we teach you how to transfer your assets. So if you have a car, if you have a house, if you have a brokerage account, stocks, bonds, precious metal, whatever it is, we teach you how to do that, right? The quick claim deeds and all of that stuff is in there. There's a bunch of resources. So your tax documents, your W-9, your 1041, all of those things are in there, right? We teach you how to apply for your EINs because it's not the same, right? The way that you apply for your business trust EIN is not the same the way that you apply for your nonprofit EIN. So we teach you how to do that, okay? And then we teach you about the investments that we were just talking about. So we have a strategic way of investing in real estate, and we teach you that in the program, as well as how to build passive income with index funds in the stock market. We teach you how to build business credit with your business trust so that you can use the business credit cards and lines of credit as down payment. And you can actually fund, like, for example, if you was to get a line of credit today for $50,000, the first place that you're going to park that $50,000 is into your insurance policy. And then you're going to borrow it back out. So now it's parked in your insurance policy, making 8% compound interest for that year. Okay. You're going to borrow that 50,000 back out, and you're going to use it as a down payment for real estate. Okay. So now you have two assets that's generating income for the trust. That's how the trust becomes self-sufficient. That's how the trust is going to have passive income. Okay. And then we also have a community. Okay. So we have a community on Facebook where you can get connected with other trustees. Okay. So the course is $997. You have lifetime access to it. And if you guys feel like you need accountability, then you can do the Done With You, right? The Done With You is a one-on-one with me. So we do a series of 5 Zoom calls. Sometimes it could be more depending on if you have a lot of assets. And then if you have no assets, then sometimes it could be less Zoom calls. So it just depends, but it's a minimum of 5 Zoom calls, unlimited questions and answers. You have lifetime access to the course, okay, which is valuable because, let's just say that we take a month to do our one-on-ones, but you want to set up a trust 2 years down the line. You have lifetime access to the portal. You just go log in, you deal with the templates, right? You download the templates, plug it in with alongside the video training, and then you set up your your trust, okay? So that's important. And then if you want to make sure that you need that accountability, a lot of people do, because what I've seen is that, you'll buy a course and you'll just sit on it and you'll not take action and you don't set up your trust, right? So you want that accountability to make sure that your trust is set up the right way and that you actually do it. So the Done With You, the one-on-one is $14.97. Okay, so those are the prices. You guys could go to thewealthytrustee.com. No, it's not The Wealthy Trustee. It's Wealthy Trustee, www.wealthytrustee.com. So that is the website, guys. So now what I want to do is I want to show you guys what a trust looks like, because a lot of people, they do not know what a trust, looks like. So I want to show you an example of what a trust looks like. Okay. And here's the contact information. So if you guys want to email me, if you have any questions, you can, or you can contact my community line at 305-749-9215, okay? So this is an example of a trust, okay? And the things that you see in red are the things that you want to fill out, right? You want to create a name for your trust, things of that nature, okay? So here we have the table of contents. These are all the sections and provisions in the trust, okay? And then we're going to go down. So this is the declaration of contract and the indenture, okay? So this is what we are, going to be going over. So this is all the rules and regulations inside of your trust. It's super powerful. The verbiage in here is, it's going to protect you, right? It deals with common law. It's going to protect you in the long run from, like I said, from any type of, lawsuits, any type of, entities that are trying to regulate you. It's just so powerful. So this is what the trust looks like. I'm just going to keep going down. This particular trust is 43 pages, okay? So you're going to customize this trust. Not all 2 people's situation is the same, right? So you are going to customize this trust. So where you see like the sections in red, you want to input whatever, whatever applies to your family, whatever applies to your business, okay, guys? And once you are done, then you are going to notarize it, right? So the grantor has to sign, you as a trustee have to sign in your respective state and county, and then it gets notarized, okay? And then you have your Schedule A where you are actually exchanging something of value so that the trust can generate the trust certificate units, okay? And then you have the position to distribute those trust certificate units. So that is what the trust looks like. And I'm open for questions if you guys have any questions.
I do.
Hi, Sabrina. How are you?
I'm very well, Christina. Thank you so much for all of that information. It was absolutely fabulous.
You're so welcome. Thank you for that. I appreciate you, Queen.
Yes, I have several questions, but for time purposes, I'm going to limit my question to one.
Okay.
So, transfer of the assets. The question that I would have, if there is an existing mortgage on the home, would transferring that asset into the trust then trigger a due upon sale or any issue with the lender?
Okay, so it can. It depends on the lender, okay? So like I said, not every mortgage company is the same, okay? So when you are transferring the asset, right, your mortgage is going to stay intact, and your mortgage company, they're not searching to see who the owner of your house is, right? So you are the owner of your house and you deed it over to the trust, but if you don't notify the mortgage company, then they're not going to know that the ownership was transferred over, okay? So if you are not letting them know, then they're not going to know, okay? But let's just say that they do find out, then all you have to do is disclose that you are the trustee and that there was no true sale, right? Because they want to make sure that you're not selling it to someone else. They want to make sure that you are still the individual that's in the house. So then all you have to do is execute like an authorization or a power of attorney so that they can now receive payments from the trust instead of from you personally, okay?
Okay. Okay. Thank you so much. I appreciate your time and the information.
You're so welcome, Sabrina. You have a good night. Thank you for attending the webinar, Queen.
Mhm.
All right, who's next? We have Tyreek.
Hey, thank you so much. I appreciate your time. Thank you for doing this webinar. It's a big help to me. I was doing some research into the infinite banking stuff, which is a concept. You can't like just go to anybody and get that done. From what I understand, and also from what I understand, doesn't it take about 3 years for the policy to mature enough to be able to borrow against it, or is that a fallacy?
That's a fallacy. It does not take 3 years. So just like how you said how you can't go to anybody, that's literally the reason why you can't go to anybody, because you have to understand that insurance agents are what? They are out here to make money. They are surviving off of commission, okay? And that commission is coming from you paying your premiums. So when they are structuring your policy, they're going to lock you in for the 3 years to make sure that you're not able to tap into your cash value, okay? And they have high commissions, so you're not even going to be able to be building cash value soon. So you have to go with the right company and you have to go with the right agent, because it's all in how it's structured. It has to be structured for infinite banking, and the agent has to, there's a non-negotiable. They have to reduce their commission in order for you to be able to build cash value and build it fast. And then they can't put any limitations in place to where you can't access your cash value at a certain time. So for example, my agent, he specializes in IULs. And so I was able to borrow out of my policy after the second month. Okay, so that 3 years is a joke. So you have to just go, it's based off of the company. It's based off of obviously the insurance company, but obviously the company that you go with in order to get your insurance set up. Okay.
Can you like give recommendations as to who we should talk to, or how, like,
Yeah.
or is that in the course?
It's in the course. So my agent actually, he taught a class, and so he taught about infinite banking, and it's in the course.
Okay.
And then I share his information. So you're gonna book a consultation, and then you can get your policy with him, and he's gonna teach you all about infinite banking, just like he taught me.
Thank you so much.
You're welcome, Tyreek. Thank you for attending the webinar.
Yes, ma'am.
All right, Coach April, how are you?
And thank you so much, Christina, again,
You're
for
welcome.
all of the wealth of knowledge. And like Sabrina, I have a ton of questions too, but I'm not going to go there. But I did have a follow-up question based upon what she said, and then kind of a secondary question. Do you have to file a UCC on the mortgage to show that you have like the first position lien if you don't own it clear and outright in order to have it in your trust? You know what I'm saying? So she was asking kind of like the bank, they're gonna know, like, it's you don't really own it, right? And so you're not selling it to someone, you're putting it in your trust, but there's still a mortgage on it. So the trust is paying for it. So do you have to file a UCC to get the first position from the bank, or no?
So, okay, I'm not familiar with UCC. Okay, so
Okay.
I'm not in that whole realm, and I can't talk about UCC.
Okay.
So, what I do want to let you know is that you don't have to, file a UCC in order for your trust to be able to own your home. Okay, so the quick claim deed, you deeding the property over to your house is still going to, it is still going to be effective, but yes, you're still going to have to pay your mortgage, right? You're still gonna have to pay your mortgage, and they're still gonna have a lien on your house. So
Okay.
now it's up to the trust to be able to have that financial responsibility to pay the mortgage every single month. But as far as what you're describing with the first lien and stuff, I'm sorry, but I'm not familiar with that.
Okay, no worries. Do you have to track the like ins and out of the trust, like the money's coming in and out in the minutes or whatever? I know you talked about board meetings, so it sounds like you need to set up a board, but outside of just the trustee, do they have to approve what comes in or what comes out? And do you have to document that in the meeting minutes?
Yeah, so when it comes to the meeting minutes, you want to only use the meeting minutes for things that are major, right? So if you are, gonna go buy a light bulb for a property, you're not gonna have a meeting because you went and bought a light bulb and you spent $10 at Home Depot.
Out of the trust, right.
So you don't have to. Your accounting and your bookkeeping is up to your discretion. Everything that has to deal with the trust is up to the discretion of the trustee. You operate the trust however you want, right? So, yes, you obviously going to have some type of bookkeeping and accounting, but that can be done through QuickBooks, and it doesn't need to be documented inside of the trust, and it doesn't need to be documented inside of the meeting. Okay, so the meeting minutes are specifically for major things like you purchasing a house, you selling a house, you liquidating assets, you opening up a bank account, you taking out a loan, things like that, not things very, small and minute, because you're operating your trust, 24/7. So you're not going to be making meeting minutes every single second of the day.
So are you only the board? Do you, the trustee, only makes up the board?
So the board, so you are the board, yes, right? When we are referring to board in the trust, we're referring to you as the trustee, right? It's called
Okay.
the Board of Trustees. You are the first board member of the trust, okay, of the Board of Trustees. Now you can appoint other officers. So those officers are going to be like a secretary, right? If you have administrative things, you want an executive secretary to be responding to emails, maybe assisting with, different things of your day-to-day operations with your trust, right? Secretarial stuff. You could also appoint a treasurer, right? So the treasurer is going to be responsible for obviously financial stuff, right? Paying bills, right? If the trust has, 10 properties, who's paying those utility bills? The treasurer, right? So you appoint all of these different positions. You also have a steward or a caretaker, right? So that's the individual who's going to be taking care of the assets. Because if you're running a big establishment, right, and you have 100 properties, it's not just you. So you're going to have other board members, but you are going to be the first initial board member. And yes, it's highly recommended and the best practice for you to have other members other than yourself. Okay.
Okay, thank you.
You're so welcome, April. Thank you for being here. Who's next? Is it Mesha? Mashia?
It's Mashe.
Mashe, that's beautiful. I'm sorry about that, Mashe.
Thank you. It's
Girl,
okay.
I did not want to mess up your name.
It's okay. Okay, so I have it's like one question, but then there's like two small questions that go with it.
Okay.
So how do you protect assets like your children that you're putting into a trust as far as court cases go?
Wait, what do you mean? Hold on, I'm confused. The asset is your children?
Mm-hmm.
How do you protect your children? Like from what? Is it child support that you're talking about? I'm confused.
So like a CPS case.
Oh, okay. Honestly, I'm not familiar with that. I really am not familiar with that because I really don't understand how, because to me, honestly, it sounds like it's on the individual side.
Mm-hmm.
So I really don't understand how it pertains to the trust other than the children being the beneficiary of the trust. But you have to understand that, if the children are involved in a litigation, it doesn't have to do with the trust and it doesn't tie the trust into the litigation or, what you're describing. So to be honest with you, I really don't know how to answer that question effectively.
Okay. And another question, when recording the trust at the county, is it just the certificate of trust or is it the full trust? I can't remember if you discussed that earlier.
So you do not have to record your trust, and I really don't understand why you would record your trust because you want your trust to be private. You don't even want anyone to know the name of your trust. You don't want them to be able to look it up on the county records. So it's not recommended for you to record your trust.
Okay.
But you can though. You can. And so if you are to record your to record your trust with the clerk of courts, then yeah, you can use your certificate of trust, you can use your declaration, you can use the signature page or the board meetings.
Okay.
Yeah. All done?
Yes, my bad.
All right, no problem. Thank you for answering your question. Thank you for asking your question. Who's next? Is it Patricia?
Hello, Christina.
Hi, how are you, Patricia?
I'm doing well, and thank you so much. This has been the best.
You are so welcome. It's my pleasure, Queen. How can
Yes,
I?
I wanted to ask you, how many entities can be inside of one trust? If I'm saying that right.
Yes, I understand. And actually, there's no limit. So you have to understand that your trust is customizable. So if you document in your trust that you can have unlimited entities, then you can have unlimited entities. Right. So it just goes based off of the governing instrument. That's what we call it when we're dealing with trust law. Right. So the governing instrument is your trust document. So you got to go based off of the verbiage inside of your trust. So if your trust says that you can only have 5 entities, that the trust can only own 5 entities, then that's what it is. It cannot own a 6th entity because that's against the contract.
Okay, and so if we had 5 people that were all within this, the structure of it, within the writing of it, within the declaration, that's fine. That's not like,
No.
not acceptable. Okay.
Right, it's fine. It's fine.
All right, and is there any way I can, how do I get a consultation with you?
Oh, yes. I think Dion put my calendar link on there. You could book a call with me and I'll be able, yeah, she did. She put it there. So it's in the chat. Thank you, Dion. It's in the chat. Do you see it, Miss Patricia?
Let me bring the
Let
chat.
me, maybe I can copy and paste it.
Yeah, I see it there. Okay.
You do?
good deal.
Okay. Yep. So
All
just
right.
book a call with me and we can discuss your particular situation.
Okay. All right. Thanks a lot.
Have a good night. Thank you so much for being here.
All right. You're
All
welcome.
right. Next, Alma One.
Hi,
Hi, how are you? How do you say your
I'm
name?
doing wonderful. I'm Awan.
Oh, Alma One. Okay, good. Perfect.
Yes.
Beautiful, beautiful name. How are
Thank you,
you doing?
Christina. First of all, thank you so much. Appreciate
You're
your time
welcome. You're
and your wisdom
welcome.
and your energy.
Yes.
I have a question regarding a trust that was set up by my husband in 2018.
Okay.
He
You were breaking up a
was the
little bit.
grantor of the trustee and myself as his wife.
You're breaking
Unfortunately,
up.
he passed away in my husband. Can you hear me?
Yes, I could hear you now. You were breaking up. I'm sorry. I can hear you now. Hello? Hello? No, you're on mute.
Hold on.
Okay, I can hear you now.
Can you hear me?
Yeah, I can hear you now.
Can you hear?
Yes.
Okay. My husband established a trust in 2018. He is the grantor along with the Most High, and he's also the first trustee, and he named me as the co-trustee,
Okay.
with our children as the beneficiaries.
Okay.
He passed away in 2021.
Okay.
And so, as the trustee, I just want to be sure, as far as moving forward and solidifying things and protecting our family better, I have authorization to be able to continue to operate the trust and make any moves that need to be made, correct?
Yes,
Even
absolutely.
though he's the, okay. I wanted
Yeah,
to know as far as,
So hold on one second. Let me just make this clear. So your husband, he was a grantor and the trustee. So it sounds like he made a revocable trust, but since he passed away, it automatically becomes irrevocable once the grantor expired. So now you have an
okay,
irrevocable trust.
which is good.
And yes, it is. It's phenomenal. And you as the co-trustee, you are now the sole trustee. So it's just you now. And
Okay, so now,
so yeah, you can start operating it. So just get familiar with the trust contents to see, the powers that you have as a trustee and to make sure that you can operate under sole discretion. And then from there, you want to appoint someone to be your successor. Okay.
successor.
Yeah,
Okay.
you want to do that, sooner rather than later.
Yes. One last question in regards to
Yes,
the
ma'am.
EIN number. When you establish the trust, we established the EIN number as a foreign EIN number. I'm trying to establish a trust fund. Would you recommend me getting a trust fund or trust account with a private bank, or what would you, how would you steer me in it? Because I tried to do it through Bank of America, which is probably the wrong thing, which is my personal banking, and they tried to tell me I had to give them trust articles and show this and show that, and gave me a whole runaround, and I kind of lost interest in it. And so I'm just trying to figure out, as far as setting up a trust account, what would be the best way for a foreign?
So what I always tell my clients is, Even if Bank of America gave you an issue, what you have to do, unfortunately, is you have to go through their legal department to be able to open up a trust bank account with them, because it's illegal for them not to allow you to open up a trust bank account. But
Okay.
but you can also go to banks that don't even require EINs, like Truist Bank. I don't know if you're familiar
Okay.
with that bank, but that bank, it
I
doesn't
am.
require you to have an EIN, and they're not gonna ask you for any paperwork. So try them and
Mhm.
let me know how it goes.
Okay, wonderful.
Yeah, absolutely.
Thank you so much.
And what you want to bring with you is your certificate of trust or your meeting minutes, okay? But you don't have to show them anything else.
So when you say certificate of trust or meeting minutes, that means all the parties that are involved in trust, we sit down and have a meeting and establish the
Yeah,
hierarchy,
yeah,
or like, because we already have trust articles and a whole trust
yeah,
agreement
I
set
know.
up. What are
Yeah,
you interpreting?
you just have to have a board meeting, and you just have to document
Okay,
that you had a meeting, that you are going to go ahead and open up a trust bank account. So the best practice is
gotcha.
to have that meeting before you even go to the bank. And then for you to
Okay.
take those meeting minutes with you.
Gotcha.
Yeah.
Okay, that makes
Absolutely.
sense. Thank you so much, Christina. I
You're
will be
so
in touch with you
welcome.
for consultation.
All right.
Peace and
Sounds
love to
good.
you. Thank you.
You're welcome. Thank you for being here. Hi, Lily. How are you?
Thank you.
Hi. Hi, Christina. I'm doing well. How are you?
I'm doing really good. Thank you for being here tonight.
Thank you so much. I can't tell you how informative this was. I think everyone's with me on that.
Yeah, I appreciate that. Thank you so much. That's my purpose. That's what I'm trying to do. I'm trying to let you guys
Your
know.
authenticity shines through.
Thank you.
I have to go for mom duty in a minute.
Okay.
But
Okay. Yeah.
this is my question is actually, so I think in the beginning you were leading us through, I think the business trust. Is that correct?
Yes, it is.
Okay, so I'm assuming slightly separate or slightly different for setting up a family trust.
As far as what? No. So that's for setting up any type of trust. Those are the steps.
Any type of trust.
Yeah, any types of
Okay.
trust. Those are
So,
just general steps.
okay. So my question is around, beneficiary versus successor. So I have one child right now.
Okay.
And so, who's under 18. And
Okay.
so if he is a beneficiary, is he also a successor? Does it need to be two different people? Kind of, what are we looking at there?
Okay, so your child is under 18, so your child doesn't qualify to be a successor. You have to qualify. So that
Okay.
means that they have to be at least 18 and older and being in the position. So at the time that you're appointing the successor, so if you were to appoint them today and they're under 18, then they're not going to qualify, right?
Okay.
So at that point, because they're going to take over for you, in the event of anything. And so they need to qualify, and they also need to accept the position too. So those are the two things with the successor. So a minor cannot be a successor. So you would choose somebody else. Now, because your child is the beneficiary, if you wanted them to be the successor, it would obviously be later on, down the line, right? Let's just say, hypothetically, when they're 30 years old, right? The beneficiary can become a trustee, but with this type of trust, they can't be the sole beneficiary, right? So if the beneficiary is the trustee, there has to also be other beneficiaries in the trust in order for that to be viable. Okay.
Okay, so I would need other beneficiaries, and let's say I passed away, then,
Yeah.
I still couldn't list him as the successor until he's
Right. You
over
can't.
18.
Yeah, exactly.
Okay.
So, and you could appoint your successor at any time. It doesn't mean that you have to appoint your successor right now, but the best practice is to do it sooner rather than later, because tomorrow's not promised.
Yeah, totally.
Yeah.
So if I were to want my kid to someday become the trustee and he's my only kid, then, I would, let's say, utilize other family members or?
Yeah, so if I were you, what I would do is I would appoint someone to be the successor right now, and then you change it
Mhm.
once he qualifies. So if you want to appoint a sibling today to be your successor, and then 5 years down the line, when your son is, 20 years old, you can then you can change it, amend it to remove that successor that you previously appointed, and now you're
Mhm.
adding your son as the new successor.
Okay, well, like you said today, tomorrow's not promised. So am I able to do that ahead of time? Say my sister is the successor until this beneficiary turns 18 if they accept the position?
You can, yeah, you can,
Okay.
but there has to be that acceptance. So whoever
Okay.
the trustee is at that time, which is probably going to be you or whoever takes over, they're going to have to make sure that the beneficiary accepts that position as the successor.
Okay.
Perfect.
Okay, thank you so much.
You're welcome, Lily. Thank you for asking that good question. Thank you for being here.
Of course.
All right, who's next? Terry?
Hello, how are you?
I'm good, Terry. How are you?
I'm great. Thank you for asking. And thank you so much for all your information. It's very valuable. I really appreciate it.
You're so welcome. Thank you for that. I appreciate you.
Yeah, so I have a few questions here. I'm going to try to make it really fast so I don't hold up anything. But in regards to the insurance policy that you were speaking on earlier, can that be done with a home insurance policy or it has to be a certain kind?
A home insurance? No, this is life insurance that we're talking.
Life insurance.
Yeah.
Okay. Just wanted to make sure. And
Oh,
then so as far as like establishing a trust bank account, I do have a business one, and I was thinking about, or I was going to see how I could convert it to, you know, something to like a trust account. I did speak to someone in the bank, and from the trust department in the bank, and he told me to basically bring him my trust. So I guess we can talk further about it. No. But I didn't, and that's the thing, I didn't know what all he wanted from my trust. So I didn't, need some
Yeah,
clarification on it.
so you never want to show your trust to anybody. Okay.
Mm-hmm.
And you just always tell them no. That's it. And so it sounds like you have to understand these bankers, they don't deal with trust. They don't have a trust. Their clients don't have a trust. They don't deal with trust. So, they just want to always refer to their legal department at the bank. So you let them, you politely let them know that they are violating your rights, and you have to contact the legal department directly to let them know that you're not going to disclose your trust, but you want to open up a bank account there. So,
Okay.
yeah.
Okay. Yeah, because the bank account, it's already a business bank account, but since I've been learning more about trust, I kind of wanted to, at least fund it or have a bank account for my trust. Can you fund your trust through like your birth certificate
I don't know what you mean
with
by
it?
that. I'm not sure what you mean by that. Through your birth certificate.
With your birth certificate.
Yeah, I really don't know the answer, honestly.
Okay.
I don't know what you mean by that. Maybe Dion knows the answer. I'm not sure what you mean by with your birth certificate.
Okay. Okay. Well, thank you so much. That was all my questions.
You're welcome, Terry. Thank you so much for asking that question.
Okay.
Juan, you have a question?
Yes, Christina. Hi. Very nice to see this whole conference that you've given. It is spot on. I mean, your advice, it is completely spot on. I've been dealing with wealth management for some years, and it's amazing the authority. I mean, you really know this stuff back and forth. So I want to congratulate you first of all, and thank you very much for sharing with all of us.
Thank you. I appreciate that, Juan.
Yes, absolutely. I guess like a question or comment. I've been reading up on the infinite banking concept a little bit. I started reading the book by Nelson Nash.
Yeah.
And one of the things that I've read was that you don't have to take out that insurance policy just for yourself. You can have it on your kids or on anyone else. And that's actually what banks do. So that's something that I wanted to also share with everyone here, is
Yes.
that you can do that.
Yeah, that is true. And I have 3 children and I have an IUL policy on all 3 of my kids. So I agree with Juan. That's powerful. And you know what? Honestly, the more policies, the merrier. That's how I feel.
Absolutely. And I was reading up on your website a little bit about your profile, that you come from nursing and then you just retire from that. And so all of this information that you're sharing with us, is that sort of like self-taught, or are you an attorney, or?
Yeah, no, I'm not an attorney. So I gave that disclaimer. So this is, I'm only sharing what I do. Okay. So this is everything that I've been doing. I've been investing since 2015. I actually used my nursing money. So I saved up $25,000 in my career and I began investing in real estate. And that's why I teach the real estate component. And then I got my insurance policy. And that's why I teach the insurance component. And then I executed my trust. And that's why I teach the trust component, because I do it myself on a daily basis.
All right, I'll be contacting you because I need some details about setting up that life insurance policy. It is very tricky, and you have to make sure you're maximizing cash value. And as you were saying, an insurance agent is there. I mean, not all of them, but most of them are there. Of course, they're protecting their interest, and so it's important to set it up right. So
yes,
hopefully we'll be talking soon. So
yes,
thank you.
I agree with you. Yeah, I'm looking forward to speaking with you too, Juan. That would be great.
Have a good night. Thank you very much.
Good night. Bye.
Good night.
Next. Who do we have next? Is it Alma? Do you have another question, or
Yes,
is that...
it's me again.
Okay.
I have one last question.
Okay,
It's me.
perfect.
I wanted to ask, since the trust is now irrevocable due to my husband's departure, does that mean that there's no way that I can make amendments as trustee? Because like, we're a tribe, and I would like to include additional beneficiaries, namely the members of our tribe. I want to add beneficiaries and make some more specific stipulations. For example, we noted that we're not 501c, but I do want to indicate that we are 508(c)(3), whatever the numbers are. Can I make amendments to the trust if it's irrevocable as trustee?
So if you are the trustee, yes, you can make amendments if it's irrevocable. The first thing that I'm going to tell you is to read your trust, because you have to know what the contents of your trust say. So if the contents of the trust says trustee cannot make amendments, then you cannot. Okay. Because you have to understand that the way that the trust was designed, it was probably most likely designed as a revocable trust. But since it's irrevocable, the trustee, yes, can make amendments at any point in time. So the first thing, your first resource is your trust document. You have to go through it, understand it, and see what the provisions are. And then and it should clearly say it in there if you can make amendments. Okay. And so
it does. It says that
you can.
That I can do. The trustees are the only ones. Yes.
Okay, so if it says that the trustee can make the amendment, then the answer is yes, you can make amendments. So you can make changes to your trust. So it sounds like you said that you want to change your trust to ministry trust. Is that what you're trying to do?
No, I want to add beneficiaries.
Oh, add beneficiaries.
Specifying the members of our tribe as additional beneficiaries in addition to our son.
Okay, yeah, perfect. Okay, absolutely. Yeah. So all you have to do is just, have a board meeting about it and add those beneficiaries to the trust.
Okay.
All right.
And that's pretty much the case for any other amendments. It's about the board meeting and establishing it with the
Yes.
board.
Yeah, so some people they get confused and they think that they have to actually like retype up the trust. No, that's not what you're doing. So if you're adding or subtracting anything from a trust, you're doing it through the board meeting minutes.
And then where do I file the minute meetings to make it applicable to the trust? Or is it just something we keep on file privately?
Why, girl, that's a good question. And that is something that I did not.
Because I want to say this, that we did file it on public record. I know you said that's not the best thing to do,
Oh,
but
okay.
that's what was done. And I want to know if moving forward with these changes I'm making, do I need to do that on public record, or can I just do it privately with the minutes from the meetings now?
Yeah, exactly. So, I mean, you can do everything. Listen, I don't recommend you do anything publicly, okay?
Good, gotcha.
Because the trust is designed for you to exercise your privacy. So it's
Yes,
the purpose to register
right.
it and to have to even go through those, those governing regulations. So to answer your question, right, the way that you want to operate your trust is you want to have a binder, and then you want to have certain sections in your binder. So remember when we were, in high school and we had these 3-ring binders and we had dividers in between the binders?
Yes.
So that's what you want to do, right? So in your binder, the first section of your trust is, of your binder is going to be your trust indenture. Okay, so your trust, your declaration, that's going to be the first section. Then your second binder is going to be all of your schedules, your Schedule A's. Then the third one is going to be all of your board meeting minutes, right? Everything. So that's what we mean when we say you have a minute, you have a board meeting and you add it to your trust. Because you're
Gotcha.
operating with this binder and then you print out, you type it up, whatever, you print it out, handwrite it, however, you're going to add it to the binder. It's added to your trust. Your trust is a living entity, so it's always going to be building upon itself. So it
Yes.
probably is going to start with 20 pages, but when you already had 3 years worth of meetings, it's probably going to end up being, 60 pages. So that third section is going to be your board meetings, right? Then the fourth section is going to have all of your assets, right? So it's going to have your warranty deed for your house, the titles for your car, all of your insurance policy, right? The information page for the insurance policies, every single asset that specific trust owns is going to be in that section. And then after that section is going to be any contracts that you have executed with that trust. So if you put the trust into a loan, a mortgage, a line of credit, anything like that, you're going to have those contracts there. And then the last section is going to be the bills, right? What is the financial responsibility of the trust, right? So the trust is responsible for utility bills, maintenance, mortgage, all of these things, right? So you're going to have those bills there too. So whatever is applicable to that one trust. So if you have multiple trusts, you're going to have multiple, wait, what was it called again? Binders.
Binders, yes.
Exactly. Yeah, you're going to have multiple binders. You don't want to mix binder A with that A trust with information for trust B. Okay. So
Gotcha.
so trust A has everything in binder A, and trust B, you're going to separate them. You don't want to be commingling all this stuff. Okay.
Would the insurance policies be filed under contracts, bills?
Assets.
Assets. Okay, gotcha. All right. I'm done. I'm not going to hold you any longer. The rest will be on the consultation. I thank you again for answering the questions and taking the
You're
time.
welcome. Yes, definitely book a one-on-one with me. I would love to talk to you.
Okay, wonderful. Thank you, Christina.
You're welcome. Have a good night, Queen.
You too. Peace.
All right. Terry Hall, how are you?
I'm good. I'm sorry to bug you. I just got another question.
Yes, ma'am.
So in regards to transferring your car into your trust, do you need the title that comes from the bank, or can you just you need that?
Yes, you do.
Okay. And so if the trust is going to be responsible for paying bills, do you have to convert the accounts to your trust as well?
So do you have to convert the accounts? So, it depends. It really depends. So you
Okay.
can contact, it depends, right, on the companies, but you can contact the companies and you can switch the accounts to the trust name. That's the best practice. Or you can, leave it in your personal name and then you can switch the payer. But the best thing to do is to switch everything under whatever the trust is responsible for. You want to switch it to their name.
Okay. All right. Thank you.
You're welcome. All right, who's next? Tyreek?
Hey, I got more questions.
All right, awesome.
You had spoke about trust law. Is there where do you find that?
So so you have to go to the law library, or you can look up different trust cases like on Google, or you can go through what's the name of this website? It escapes me right now, but there's a website where you can look up different cases. So it depends, but you can, oh, you know what? I can't remember the name of the website right now. I do apologize. But if you send me a text to my community line, I'll be able to send you the link.
Is the community line in the chat?
Mm-hmm.
Okay.
Sure
I'm gonna
is.
look that up. Another thing, yeah, like if you when you sign up, like do you get an affiliate link or something like that?
Yeah, absolutely. So I haven't started I'm creating an affiliate program, so I should have that up and running by next week. But yeah, you can become affiliate.
Awesome. I think you did a great job. Not that it matters, but yeah, you knocked it out the park. I appreciate it.
You're welcome, Tariq. Thank you so much. You're so nice. I appreciate you. Thank you for being here tonight. And thank you to everybody for being here tonight. I know it's getting late. It's already 10:15. If I don't have any other final questions, then I'm going to let you guys go for the evening. And it's in the chat, so you guys could book a call with me. If you want, you can go to the website, wealthytrustee.com, if you want to sign up, or you can just text my community line and I'll be able to answer any questions that you guys might have, okay?
Christina, can I ask a quick question about your course?
Yeah, absolutely.
Thank you. Was looking through the website, but do you also cover building business credit with the business trust?
Yes, I do. Yeah.
That's part of it? Okay.
Yeah, it is. Yep.
Thank you.
You're welcome.
Christina, can I ask you just one more clarification question too? It's gonna be.
Yeah.
So is listing the assets in the trust, like in the documentation, is that not enough protection? You actually have to go and do like transfer, quick claim deed, or with the motor vehicle or with the insurance policy to actually transfer it over. Is that an accurate assumption?
That is 100% accurate. You actually, just by you putting it in the trust, nobody knows that the trust owns that asset because you're not showing it to anybody. You have to
Okay,
actually transfer the ownership of the asset.
gotcha. I just wanted to clarify that with the public record and like having it out there versus not versus transferring over and being public. So perfect.
Yep.
Thank
You're so welcome. Thank you. Thank you,
I have
everybody.
one more question, just a
Yeah.
quick question as well. So just in a regular court case, how do you express the trust in court?
So, how do you express this trust in court? So you don't have to bring your trust, like, you don't have to bring your trust to court, unless the judge makes a judgment that you have to bring your trust, and then the judge is going to go through the trust.
Okay, thank you.
You're welcome. All right, good night, everybody.